Chapter 30. Larceny. Section 533. Definition. Larceny is the taking and removing of personal property of another by trespass with knowledge that neither the general nor special ownership of the property is in the taker, and with felonious intent to deprive the owner of his ownership therein. Section 534. Essentials. The essential elements of larceny are as follows. 1. The thing taken must be personal property. 2. The taking must be by trespass. 3. The general or special ownership of the property must be in another. 4. The property must be removed. 5. The taking and removing must be done with felonious intent to deprive the owner of his property. 6. The property must have some value. Section 535. Nature of the subject matter. The thing taken must be of such a nature that the law regards it as property, and thus capable of being owned. Hence animals fernach which have not been reclaimed, or which, though reclaimed, are unfit for food or valuable for their fur, cannot, at common law, be the subject of larceny. It has been held, therefore, that dogs, cats, bears, foxes, apes, monkeys, polecats, ferrets, squirrels, parrots, singing birds, martens and coons are incapable of being the subject of larceny. While on the other hand it has been held that deer, hares, conies, pigeons, doves, pheasants, partridges, cranes, swans, wild boars, wild turkeys, wild geese, wild ducks, oysters, and certain kinds of fish, when reclaimed, are capable of being the subject of larceny. Yet in many places squirrels, coons and bears are used as food, and a better distinction might be, not whether the animals were capable of use for food, but whether they were kept for food purposes. Section 536. Dogs. Some courts hold that dogs can be the subject of larceny. Other courts, however, hold the contrary. The two reasons assigned for the latter view are, 1. The baseness of their nature, and, 2. The fact that they are kept for the mere whim and pleasure of their owners. This reasoning is scarcely sound. There are many chattels protected which are used only for pleasure. Dogs have a commercial value, large in some instances and in many ways render useful services. It is also held that dogs are subject of larceny for the reason that they are made taxable by statute and therefore are deemed property. Section 537. Killing animals. When a hunter kills a wild animal on another's premises and removes it under circumstances which render the killing and the exportation parts of the same transaction, so that in the eye of the law there is continuity of possession in the trespasser, he is not guilty of larceny. If he abandons it after killing it and subsequently returns and removes it animo furandi, he is guilty of larceny. In the latter case possession is transferred from the owner of the premises to the trespasser, while in the former case possession is continuous in the trespasser. The question of abandonment in this class of cases involves the question of intention. If the trespasser, at the time he goes away, intends to return for the animal within a reasonable time, he does not abandon it. Thus, where hunters killed and concealed 126 rabbits on another's premises, and returned after several hours and carried them away, the court held that there was a continuity of possession in the trespassers and that for this reason they were not guilty of larceny. It has been held that where domestic animals were killed and their flesh or hides taken away and sold, it was larceny. Section 538. Fruit trees, fixtures, etc. The principles involved where a hunter kills a wild animal on another's premises and removes it are also applicable where fruit is severed from a tree and carried away, where natural grass or standing trees are cut and removed, and where fixtures are severed from the realty and taken away. If a man enters my orchard and fills a wheelbarrow with apples, which he has gathered from my trees, he is not guilty of larceny, though he has certainly possessed himself of my property, and the same principle is applicable to wild animals. The common law distinguished between things that are connected with or savour of the real estate, and those that are personal goods. An apple growing upon a tree was connected with the land by means of the tree that bore it, and so held to partake of the nature of the land and to be real estate. One who plucked it from the tree and at once ate or carried it away was therefore a trespasser, but if he laid it down, and afterward carried it away, so that the taking and the exportation were not one and the same act, then, if the carrying away was done animo furandi, The elements of larceny were present. At common law, the gas and water pipes of a house, its doors, window shutters, mantles, etc., cannot be stolen, unless they are severed from the house under circumstances which render them personal property. Similarly, on which has not been mined and natural ice which has not been cut are incapable of being stolen. On which has been mined, and ice which has been cut and stored, or cut and merely placed ready for hauling away, are personal property and therefore capable of being stolen. It has been held, however, that where a person takes coal which has been deposited by a stream on another's land, sifts it, loads it on a flatboat and carries it away animo furandi, he is guilty of larceny. There have been attempts to connect one who defrauded the owner of land and obtained title to it, of larceny, but this cannot be done. Section 539. Chandeliers, keys, etc. Chandeliers, though attached to a house, are deemed furniture, and therefore capable of being stolen. And the keys of a house, though they would pass with the inheritance, have been held the subject of larceny. Thus, a refusal by the trial court to instruct the jury that the key in the lock of a door of a house, and belonging thereto, is part of the realty, and not the subject of larceny, unless the same is first severed from the realty by one act, and then stolen by another and distinct act, was held not erroneous for the reason that the keys of a house, though they follow the inheritance, are nevertheless personal property. It has also been held that the valves attached to a pump and boiler which were used for irrigating purposes, and which constituted permanent improvements to the real estate, were capable of being stolen, since they were easily removable. The court held, however, that where they were 540 is gone. Section 541. Manure. Manure which is piled in a heap for subsequent disposal is personal property and therefore capable of being stolen, but manure which has been spread upon the land is real estate and therefore incapable of being stolen. Section 542. Gas, water, etc. Illuminating gas and water supplied in pipes to consumers are personal property and capable of being stolen. Electricity, however, is not, at common law, but in some states it is made the subject of larceny by statute. Section 543. Gambling devices. Liquor illegally kept for sale. The fact that intoxicating liquor is illegally kept for sale does not render it incapable of being stolen. But whether devices used for gambling are the subject of larceny or not is a question upon which the decisions are in conflict. Section 544. Abandoned property. Property which has been wholly abandoned by the owner is not the subject of larceny. But pigs, which had been bitten by a mad dog and shot and buried on the owner's land, were held not abandoned property, and the defendants who had dug them up and sold them, animo furandi, were held guilty of larceny. $545. Body of dead person, grave clothes, etc. The body of a dead person is not the subject of larceny at common law, but the coffin containing the body, and the grave clothes, are. The clothes on the body of a dead person who has been drowned and driven ashore from a wreck are likewise the subject of larceny. Section 546. Value of the property. To be the subject of larceny, the thing taken must be of some value. The slightest value, however, is sufficient. Even a piece of paper can be the subject of larceny. But, as heretofore stated, a paper which constitutes evidence of a chosen action cannot be the subject of larceny because the paper becomes evidence of a right, and ceases to have any existence as anything else. The same principle is applicable to title deeds, for they are evidence of title to lands. Dead infected animals which have been buried still retain sufficient value to be the subject of larceny. Section 547. Mode of taking. Trespass. One of the essentials of larceny at common law is that the taking must be by trespass. It must be done under such circumstances that the taker would be liable in an action for damages for trespass to goods. To constitute trespass, the taking must be unlawful and without the owner's consent. Ownership, however, may be special as well as general. Moreover, the general owner can commit larceny by feloniously taking the property from the possession of the special owner. Thus, a pledgee has a special property in the thing pledged, and if the pledger, who has a general property in it, takes it from him without his consent, and with the fraudulent design of depriving him of his security, he commits larceny. Furthermore, Even where the pledgee consents to the taking for a particular purpose, the pledger is guilty of larceny, if the taking is with the fraudulent design of depriving the pledgee of his security. Section 548. Possession versus custody. Possession may be either actual or constructive. Where goods are in the bare charge or custody of a mere servant, the constructive possession of them is in the master. In such case the servant has no special property in them, and for this reason if he fraudulently converts them to his own use he is guilty of trespass and larceny. So a servant who had charge of his master's mule and took it from the plough while in his custody, was nevertheless guilty of larceny. The custody of a servant is distinguishable from the possession of a bailee by reason of the fact that the bailee is under a special contract with respect to the goods which gives him a special property in them, whereas a mere servant has no such special property. Hence a bailee who converts them to his own use does not commit a trespass, and therefore is not guilty of larceny, unless at the time he receives them he has a felonious intent to wrongfully convert them. But if such intent exists at the time he receives the goods, his possession is unlawful and he is guilty of trespass, and a subsequent conversion of them to his own use is larceny. So, one who hires a horse from a livery stable with an intent at the time to steal it, is guilty of larceny. And where a bailee of goods breaks the package in which they are contained and takes out some of the articles, animo furandi, he has terminated the bailment, and may be convicted of larceny. On the other hand, where the owner of a horse gave the defendant permission to ride it to a certain place, with instructions to turn it loose there, and while on the way the defendant exchanged the horse for an overcoat, and the proof did not show that possession of the horse was obtained by any false pretext, on with intent to deprive the owner of his property, the court held that he was guilty of larceny. And where a bailee of clothes to be repaired took money from the pockets, a conviction of larceny was sustained. Also a conviction may be had for taking a box of matches placed on a store counter for the use of customers or the public. Where a third party hands money or other personal property to a servant with instructions to take it to his master, and instead of so doing the servant wrongfully converts the property to his own use, he is not guilty of larceny. This is owing to the fact that in such case the master has neither the actual nor constructive possession of the property. One who receives money to change or count, in the presence of the owner, and appropriates it, is guilty of larceny. Section 549. Finding lost property. Whether the finder of lost goods is guilty of larceny or not depends upon the circumstances of the particular case. If at the time he finds them he knows who the owner is, or has reasonable means of gaining such knowledge, and at the time of the finding appropriates them animo furandi, he is guilty of larceny. If, however, the felonious intent is formed afterward, the finder is not guilty of larceny, even where he has knowledge at the time of the finding of the true ownership of the goods. Section 550. Property merely mislaid. There is a clear distinction between property lost and property mislaid, put down, and left by mistake, under circumstances which would enable the owner to know the place where he had left it, and to which lie would naturally return for it. Where the property taken is merely mislaid, the fact that the wrongful intent is subsequently formed is immaterial. Where a person bought at public auction a piece of furniture and some time after the delivery of the same he discovered money in a secret drawer and appropriated it animo furandi, he was held guilty of larceny. Again, where a bureau was delivered to the defendant to repair, and subsequently he discovered 900 guineas in a secret drawer and appropriated the money animo furandi, he was held guilty of larceny. As said by Lord Eldon, in this case, to constitute felony there must of necessity be a felonious taking. Breach of trust will not do. But from all the cases in Hawkins there is no doubt, this bureau being delivered to the defendant for no other purpose than repair, if he broke open any part, which it was not necessary to touch for the purpose of repair, but with an intention to take and appropriate to his own use what he should find, that is a felonious taking within the principle of all the modern cases, as not being warranted by the purpose for which it was delivered. If a pocketbook containing banknotes was left in the pocket of a coat sent to be mended, and the tailor took the pocketbook out of the pocket, and the notes out of the pocketbook, there is not the least doubt that is a felony. So, if the pocketbook was left in a hackney coach, if 10 people were in the coach in the course of the day, and the coachman did not know to which of them it belonged, he acquires it by finding it certainly, but not being entrusted with it for the purpose of opening it, that is a felony according to the modern cases. The defendant, a hackman, took the prosecuting witness to meet a train, and upon arriving at the station the latter left with him a quilt and requested him to return it to the owner's home, which the defendant agreed to do, but instead of so doing took it to a store and sold it, a request by the defendant that the court charge the jury that if the quilt was received with intent to deliver it as requested and the intent to sell it was subsequently formed, they must acquit, was held properly refused, since the defendant had mere custody of the quilt rather than possession of it. $551. Property delivered by mistake. If property of one person is delivered to another by mistake and he appropriates it, he is guilty of larceny if at the time of the taking he knew it was not his, and then had the intent to keep it. But if he acquires it believing it his and afterward forms the intent of keeping it, it is not larceny. These rules are applied where money and checks have been mistakenly delivered to one other than the owner. Section 552. Possession or custody obtained by fraudulent trick. Where possession or custody of the chattel is obtained by means of a fraudulent trick, the taker commits trespass, and if he converts it to his own use, animo furandi, he is guilty of larceny. It is to be observed, however, that if he obtains title to the property he is not guilty of larceny. It is sometimes difficult to discriminate between these two classes of cases. The following examples will help to elucidate the distinction. 1. Defendants obtained cigarettes from a slot machine by fraudulently putting into it metal discs about the size of a penny, and appropriated the cigarettes to their own use animo furandi. In doing so they acquired mere possession and not title, and therefore were guilty of larceny. Similarly, they would have been guilty of larceny of the cigarettes had they fraudulently used a penny with a hole in it with a string attached. In withdrawing the penny after it had accomplished its purpose, they would not have been guilty of the larceny of the penny for the reason that they would not have parted with possession of it. 2. Defendant hired a mare with intent to steal her and subsequently converted her to his own use by selling her. Judge Ashurst instructed the jury that if the prisoner hired the mare to take the journey mentioned, and afterward changed his mind and sold her while the privity of contract subsisted, they should acquit him, but if they found that the journey was a mere pretense to get possession, and he hired her to steal her, they ought to convict him. The jury found him guilty, and on appeal 10 of the 11 justices were of the opinion that so obtaining the mare by fraud and falsehood, intending then to steal her, was larceny at common law. 3. Defendant's pal pretended that he had found a purse containing a receipt for £210 for a diamond ring and also the ring, and the prosecutor, who was with the pal at the time, was fraudulently induced by the confederates to give the pal 20 guineas and 4 doubloons and take the ring and keep it until the next day when the three were to meet again, at which time the prosecutor was to receive the money back and also 100 guineas additional as his share of the find, and return the ring to the defendant's pal. Instead of so doing, however, the latter kept the money given him by the prosecutor, and the jury convicted him of larceny. On appeal, 9 of the 11 justices affirmed the conviction, the other 2 dissenting on the ground that the money paid by the prosecutor was alone on the security of the ring, which the prosecutor believed to be of much greater value than the money advanced on it, and therefore that he had voluntarily parted with the possession of the money. All the judges agreed, however, that in considering the nature of larceny it was necessary to discriminate between the parting with the possession only and the parting with the property, that in the former case it was larceny and in the latter not. 4. Defendant was convicted of the larceny of a quantity of bacon and hams. The proof showed that he went to S shop and told A that B had asked him to call there and get some bacon and hams for him, that he produced a writing which purported to be signed by B, and which requested A to send him the meat by the defendant and which stated that B would pay for it. The next time he went to town, that A, believing the writing to be genuine, delivered the meat to the defendant, and that subsequently he learned that the writing was a forgery. On appeal, all the justices held that the conviction was wrong for the reason that the prosecutor parted with the property and not merely the possession of it. 5. Defendant was convicted of the larceny of certain goods. The proof showed that by falsely and fraudulently representing himself as the agent of another he obtained the goods of the prosecutor. On appeal, the conviction was affirmed on the ground that the defendant acquired only the mere custody of the goods. In this case Justice Simmons, speaking for the court, says, Harris fraudulently represented to High and Ryan's sons that he was the agent of Moore and Marsh. They did not sell him the goods, nor did they intend the title to go into Harris, but they simply delivered him the custody of the goods, to be delivered by him to Moore and Marsh. He having converted the proceeds of the sale of the boxes to his own use, he was guilty of larceny. The title still remained in the vendor. Harris got the custody of the goods wrongfully and fraudulently. 6. Defendant was convicted of the larceny of 5 quarters of wheat. The proof showed that he obtained the wheat from the servant in charge of the storehouse where it was stored by falsely and fraudulently representing to him that he had been sent for it by another superior servant in charge of another storehouse. On appeal, the conviction was affirmed. 7. Defendant was convicted of the larceny of $2 in money, a watch and some jewels. The proof showed that he falsely and fraudulently represented to prosecutor's wife that her husband had been arrested for striking a man on the head with a chair, and that he would be put in jail if he could not produce $12, for which he had sent defendant to her, that the wife had only $2, but, at defendant's suggestion, she gave him this, together with a watch and some jewels to pawn, and directed him to take the money and the pawn ticket to her husband, but that, instead of so doing, he appropriated the $2 and the chattels to his own use. The trial court instructed the jury that if they found that defendant, when he obtained the property, had a felonious intent to keep it, he was guilty of larceny. On appeal, the conviction was affirmed. In this case, Justice Allen, speaking for the court, says, the accused obtained the custody of the chattels and money of the prosecutor from his wife by a fraudulent device and trick, and for a special purpose, connected with the falsely represented necessities of the owner, with the felonious intent to appropriate the same to his own use. He did not pawn or pledge the goods, as he proposed to do, but did appropriate the same to his own use, in pursuance of the felonious intent with which he received them. This constitutes the crime of larceny. The owner did not part with the property in the chattels, or transfer the legal possession. The accused had merely the custody, the possession and ownership remaining in the original proprietor. The conviction was right and the judgment must be affirmed. 8. Defendant was convicted of the larceny of $280 in currency. The testimony of the prosecuting witness was, the defendant asked me if I was going to take that train. I said, yes. He said he thought he would go on that train. 2. Then a man came up to us and said to the defendant, if you want to go on that train, you had better get your baggage and pay your freight bill. The defendant then said, confound those fellows, they won't pay me any premium on my gold, and I have no other money to pay this freight bill, and I don't want to give them $280 in gold and get no premium. He then said to me, will you let me have $280 in currency, and I will give you this gold too? Hold as security until I can go to the bank. And furthermore, that the prosecuting witness took the pieces offered, believing them to be gold, gave the defendant the $280 in currency and soon afterward discovered that he had been buncoed with bogus coin. On appeal, the conviction was set aside on the ground that title to the currency passed to the defendant. In this case, Chief Justice Sylvan, speaking for the court, says, the testimony of the witness was that he voluntarily delivered the money to the defendant and never expected to get the same money again. It is true he was induced to make the loan through the fraud and false pretenses of the defendant. No doubt a crime was thus committed by the defendant, but it was the crime of false pretenses, and not larceny. To constitute larceny in a case where the owner voluntarily parts with the possession of his property, 2 other conditions are essential. 1. The owner, at the time of parting with the possession, must expect and intend that the thing delivered will be returned to him or disposed of under his direction for his benefit. 2. The person taking the possession must, at the time, intend to deprive the owner of his property in the thing delivered. But where the owner intends to transfer, not the possession merely, but also the title to the property, although induced thereto by the fraud and fraudulent pretenses of the taker, the taking and carrying away do not constitute larceny. 9. Defendant was convicted of the larceny of 5 shillings. The proof showed that he had a stand at certain races and took bets, that he took 5 shillings of prosecutor on a bet by the latter that a certain horse, Bird of Freedom, would win, that this horse won and prosecutor went for his money but found that defendant had absconded with it. On appeal, the conviction was affirmed. In this case Justice Smith says, I think that it is clear the prosecutor never intended to part with the property in the 5 shillings except on condition that a bona fide bet was made. I think also that there is evidence that at the time the prosecutor handed the 5 shillings to the prisoner intended to keep possession of the money, whether bird of freedom lost or won. He therefore obtained the possession of the prosecutor's money by means of a preconcerted and premeditated fraud. In other words, by a trick. There was, therefore, abundant evidence of larceny, and, in my opinion, the conviction should be affirmed. The other justices rendered similar opinions. 10. Defendants were convicted of the larceny of $1,000 in money and a promissory note for $4,000. The proof showed that they induced the prosecuting witness to give them the money by falsely and fraudulently representing that they would transfer to him within 30 days counterfeit bank bills of the face value of $25,000. Which they failed to do. On appeal, the conviction was affirmed on the ground that the prosecuting witness parted with possession only and not title to the property. 11. 1. Who with intent to convert the proceeds to his own use, secured from his fiancée a conveyance of property upon the representation that he would sell it and could sell it, to better advantage than she could, and would turn the proceeds over to her and then sold the property and appropriated the proceeds, was held guilty of larceny. Since, though she conveyed the title to the property, she did not part with the right to the proceeds. 12. One who represented that he had inside information of the operations of the New York Stock Exchange, and organized a Franklin syndicate and promised to pay 10% weekly on money deposited, was held guilty of larceny. Section 553. Ownership must be in another. To constitute the crime of larceny, ownership of the property must be in another. It may be special, however, as well as general. It is not essential that the person from whom the property is taken, have the legal title. In fact, he may have absolutely no title at all, as where the taker steals from a person who himself has stolen it. In such case ownership may be laid in the indictment in the thief from whom the property is taken, or in the general owner. A bailee has special ownership in the chattel, and even the general owner is guilty of larceny in appropriating it animo furandi. And where the general owner clandestinely removes property from the rightful possession of another who has a valid lien on it, he is guilty of larceny. Similarly, the general owner of chattels which have been levied on under execution is guilty of larceny if he takes them animo furandi. There is no doubt a man may be guilty of larceny in stealing his own property, when done with intent to charge another person with the value of it. Again, one is guilty of larceny where he takes property animo furandi which is in the possession of his co-owner as bailee. At common law, husband and wife are regarded as one person, and for this reason one spouse cannot steal from the other. But in those jurisdictions where the husband's interests in his wife's personal property is abolished by statute, he can be guilty of larceny in appropriating them. Where a third person assists the wife in appropriating her husband's property, he is not guilty of larceny, unless she has committed, or intends to commit, adultery with him. Where clothing or other chattels are stolen from the body of a dead person, ownership may be laid in his executors. $554. Asportation of the property. One of the essentials of larceny is removal of the property. The slightest removal, however, is sufficient, provided the taker has absolute control of it even for only an instant. Where, in a case, the proof showed that the accused went behind the prosecutor's counter, opened the money drawer, took the money contained therein in his hand and disarranged the bills, but upon being discovered left the money in the drawer, the conviction was affirmed. In another case the proof showed that the accused opened a money drawer, lifted $6, but upon being discovered dropped it, and his conviction of the larceny of the entire contents of the drawer, $51, was affirmed. Where the thief snatches an earring from a lady's ear and drops it in her hair, or lifts money an appreciable distance in another's pocket, or takes clothes from a bedroom into a hall adjoining, or lifts a sword partly out of its scabbard, or removes a chattel from one end of a wagon to the other, or removes grain from the owner's garner in a mill to the thief's garner adjoining, or removes a money drawer from a safe to the floor, or rolls tubs of butter from one end of a car to another and changes the address tags, so that the carrier will transport them as his agent, the asportation is sufficient to render the offence larceny. On the other hand, merely setting a bale, or barrel, upon end, or killing or trapping an animal, or shooting and wounding an animal, or unfastening a dress on a display model in order to remove it, has been held insufficient. Section 555. Asportation by enticement. The asportation may be effected by means of enticement. Thus, an animal may be stolen by enticing it away by means of food. It is essential, however, that the thief acquire dominion over it. If one entice a horse, hog, or other animal, by placing food in such a situation as to operate on the volition of the animal, and he assumes the dominion over it, and has it once under his control, the deed is complete. But if we suppose him detected before he has the animal under his control, yet after he has operated on its volition, the offence would not be consummated. It is to be observed, therefore, that it would seem there can be no asportation, within the legal acceptation of the word, without a previously acquired dominion. But, as said in the same opinion, where a person takes an animal into an enclosure, with intent to steal it, and is apprehended before he can get it out, he is guilty of larceny. In this case the defendant was convicted of the larceny of a hog. The proof showed that his confederate got some corn and an axe, that the confederate, having given defendant the axe, told the hog some 20 yards by dropping some of the corn on the ground, that the defendant then struck the hog with the axe which caused the animal to squeal, whereupon both men ran away leaving the hog where it fell. The conviction was set aside on the ground that there was not a sufficient caption and asportation to constitute larceny. Section 556. Asportation by innocent agent. The asportation may also be effected by means of an innocent agent. There is no occasion that the carrying away be by the hand of the party accused, for if he procured an innocent agent, as a child or a lunatic, to take the property, he will himself be a principal offender. An asportation may be effected by means of innocent human agency, as well as by mechanical agency, or by the offender's own hand. In the case from which the quotation is taken, the proof showed that one Carr, owner of a trunk, checked it at Worcester for Hartford, that one Briggs, defendant's confederate, checked his valise at Worcester for New York, that defendant surreptitiously interchanged the checks on the trunk and valise, in consequence of which the trunk went to New York, where Briggs took it from the station. The defendant was convicted of the larceny of the trunk and its contents, and appealed the case to the Supreme Court. In the opinion, Justice Lord observes, the real question was, whether the defendant, at that time, feloniously and with intent to steal, set in motion an innocent agency, by which the trunk and contents were to be removed from the possession of the true owner, and put into the defendant's possession, and whether such purpose was actually accomplished, and the conviction is affirmed. Section 557. The caption and asportation must be felonious. The taking and removal must be done animo furandi. The intent must be to deprive the owner permanently of his property, and it must concur with the caption and asportation. Thus, where one borrows or hires a horse intending to return it, but subsequently changes his mind and converts it by selling it, he is not guilty of larceny. Nor is the taker guilty of larceny where his intent is merely to deprive the owner of his property temporarily. Thus, where he takes another's horse to go a short distance, intending to return it, he is not guilty of larceny. It has been held, however, that where a person takes another's horse, without his consent, to ride a short distance, intending to turn it loose to stray back, that he is guilty of larceny. But this view is not sustained by the weight of authority. Where one takes another's property with intent to return it to its owner upon receiving a reward for so doing, he is guilty of larceny. And where his intent is to sell it back to the owner, or to apply it on a debt owing to the owner by the thief, or to induce the owner to sell it at a reduced price, it is sufficient to render the offence larceny. Where the property is taken with intent to pledge it and subsequently to redeem and return it to the owner, the act constitutes larceny. Some decisions are to the contrary. According to the better view, the taker's intent to redeem and return the property to the owner, and his ability to do so, are immaterial. It is to be observed, therefore, that the term permanently, as used in the definition of larceny, has a restricted meaning. It does not mean precisely keeping the specific property from the owner's possession. So a conviction of larceny was upheld where the defendant and two others took from the owner, without his consent, 2 geldings which they secreted in the woods, some 3 miles distant, for the purpose of securing a reward which the parties to the transaction expected would be offered for their return, and the result contemplated was accomplished by their return and a receipt of the reward offered. Section 558. Asportation need not be for benefit of taker. Some authorities hold that to constitute larceny the caption and asportation must be done lucri causa. These authorities, however, are not in accord with the better view, or weight of authority. It has been declared not to be larceny, but malicious mischief, to take the horse of another, not lucri causa, but in order to destroy him. Bishop's view is in accord with the weight of authority. The gist of the criminal intent is the purpose to deprive the owner of his property rather than to benefit by the act. The rule is now well settled, that it is not necessary to constitute larceny, that the taking should be in order to convert the thing stolen to the pecuniary advantage or gain of the taker, and that it is sufficient if the taking is fraudulent, and with an intent wholly to deprive the owner of the property. The reason of the law is to secure a man's property to him, and that is to be carried out, rather by punishing the thief for feloniously depriving him of it, than for the wrongful gain he has made by the theft. The moral wrong is founded in the wrongful and felonious deprivation. It is immaterial whether the motive of the taker was to benefit himself or injure another. Thus, where one took 2 horses, saddles and spurs, and removed them about 3 miles, his object being to put the owner to all the expense and trouble possible in order to find the property, and he had no idea of benefiting himself in any way, his only object having been to get revenge, a conviction was sustained. The term lucri causa, it may be well to observe, is not restricted in its meaning to some pecuniary advantage. It includes benefits of every kind. Thus, where the defendant had applied for a position as cook for a certain person, and, knowing that a former employer had written to this party an unfavorable letter relative to her character, she called at the post office and by means of false representations was given the letter, which she subsequently burned. The court held that supposing lucri causa to be an essential element of larceny, which was not admitted, the benefit she gained by destroying the letter was sufficient to supply this ingredient. Section 559. Not larceny where taken under claim of right. Where the property is taken under a bona fide claim of right, however unfounded the claim may be, the offense is not larceny. This is owing to the fact that the element of felonious intent is lacking. It is immaterial whether the unfounded claim results from a mistake of law or a mistake of fact. Thus, where the defendant had sold an organ, and a dispute arose as to the amount due on it, took it from the prosecutor's home owing to his refusal to pay what the defendant claimed was due on it, informing the prosecutor's wife at the time where he was going to leave it, and that her husband could come there and get it upon paying the balance due, the court held that the element of felonious intent was lacking to make the offense larceny. Again, where the defendant was convicted of the larceny of a sewing machine, and the proof showed that he had once owned it, that when a judgment creditor seized and sold it on execution he claimed that it was exempt from seizure, that the judgment creditor obtained it from the purchaser at the execution sale and left it with another person who desired to purchase it on trial, that defendant, acting under the advice of his attorney, peaceably took it from this person, explaining to him under what right he claimed it and giving him a receipt therefor, and stating his name and place of residence. The higher court set aside the conviction and dismissed the case. Where the property is taken with the intent to get false credit for work done relative to it, the intent is felonious. In this case the defendants were convicted of burglary. The proof showed that they broke into a cotton house where seed cotton was stored and carried a quantity of the cotton to a field with the view of getting paid for picking it. On appeal, the conviction was affirmed. The court said, "We think deprivation of the ownership of property is one of the essentials of larceny. But, is it necessary that the intent shall be to deprive the owner of the whole property taken? Is not the animus ferandi as manifestly shown, when the intent is simply to deprive him of a partial, though unsevered interest in the property? The taking and asportation were with the intent of depriving the owner of property, which was absolutely his and in his possession, and fraudulently placing it where the taker could assert a lien, or claim to hold it, until certain charges were paid him by the owner. The contrary, however, has been erroneously held in a case where the defendant was employed to tan hides and was paid by the piece, and he secretly entered the house where dressed hides were kept, and removed 120 hides. which he was charged with having stolen with intent to add them to those which he had dressed, with the view of getting credit for the work done on them. On appeal, the 5 judges who heard the case held unanimously that the conviction should be set aside because the defendant had no intention of depriving the owner of the hides permanently, nor of taking them entirely from the owner's possession. Section 560. The property must have some value. It is essential to the crime of larceny that the property taken have some value. Thus, a void check is not the subject of larceny, except to the extent of the value of the paper upon which it is written. At common law, choses in action are not the subject of larceny, nor is the paper upon which they are written, for the reason that it merges in the choses in action. And even where the chose in action is unenforceable because not properly stamped, the paper upon which it is written is not the subject of larceny because the former is still capable of being rendered available as evidence. Upon this point Lord Chief Justice Campbell says, by the common law, larceny cannot be committed of a chose in action. Strictly speaking, the instrument of course is not a chose in action, but evidence of it, and the reason of the common law rule seems to be that stealing the evidence of the right does not interfere with the right itself. Jus non in tabulis, the evidence may be taken but the right still remains. I agree that we must look at the state of the instrument at the time of the larceny committed, but it then had a potentiality of being rendered available, and it was evidence of an agreement. It was therefore evidence of a chose in action, and not a subject of larceny. In another English case the defendant was indicted for robbing the prosecutor of a promissory note for £2,000. The proof showed that by putting him in fear she compelled him to sign the note which was written on a piece of stamped paper which she had furnished. The court held that it was essential to the crime of larceny that the property stolen be of some value, that the note in question did not import, on the face of it, either a general or special property in the prosecutor, and that it was so far from being of any the least value to him that he had not even the property of the paper on which it was written. Dogs, at common law, as heretofore stated, were not the subjects of larceny. This rule, however, was changed in England by Act of Parliament, and in this country similar statutes obtain in some of the states. Section 561. Forms of larceny. Larceny, at common law, was divided into grand larceny and petty larceny, depending upon the value of the property stolen. Where the value was 12 pence or more the offence was grand larceny, and where it was less than that amount the offence was petty larceny. Larceny, both at common law and by statute, is divided into simple larceny and compound larceny. In both classes the property taken must have some value, but the amount is immaterial so far as classification is concerned. Compound larceny is committed where the circumstances are aggravating. Where the property is taken from the person of another, or from a building, the offence is compound larceny. Some courts hold that it must be taken without the owner's knowledge. Other courts, however, hold the contrary. The latter is the better view and the weight of authority.